Hey, everybody. I think I only had a few RSVPs to this event, but I'm so excited to deliver this brief talk about disability and divorce. And I am recording, so I'm going to post this to the circle. For those of you listening elsewhere, the Circle of Care is our brand new soft launch to full launch this year. It's a group membership that is designed to make a community, and everyone is welcome. Anyone who has touched disability in their life, whether as a parent, a caregiver, a supporter, an individual with a disability, or a professional in the field who serves people in this community, we welcome everybody. And I think we're rocking and rolling with about 150 members so far. I'm hoping to move the thousands of people that follow me in other places over here. Until April 30th, we are letting people in for free. So just ask me how. Hope to see you here. Okay. When it comes to disability and divorce, there is really three categories that need your attention, that are most troublesome or really attract the most conflict and controversy. The first area is around guardianship. So I'm speaking mostly as, parents who are divorcing and they have adult children or soon to be adult children, and they are considering guardianship or they have a guardianship in place. Some of the things that really are difficult to overcome is around making decisions together. A family that was once functional, or maybe not so functional, but you had different rules for how things operated when you were married. There was an assumption that people were sharing information, and that even though two people might not have been present at every signing, every event, then at the very least, people felt confident that they were in the loop. Things change when you're divorcing. In the state of Massachusetts, we have paid caregiver programs for adults with disabilities, and many parents opt to forego being co-guardians so that one person can receive a caregiver payment. This is different from state to state, but in our state and in many states, you cannot be a legal guardian and a paid caregiver. It's a crazy, silly rule, but there it is. And because of that, many people have to choose between a caregiver payment program and being the legal guardian. And hopefully they were counseled well when they went in for their guardianship decree and understood what they were giving up by not being the co-guardian. Let me circle back on that. But the real issue arises when communication breaks down and people are divorcing. They don't have that trust that they are going to receive all the information. And many families really disintegrate at this point. And it becomes very challenging that one person is the guardian, maybe has been the guardian for 5, 10, 15 years before the divorce happens. Sad, I know, but we see it like every week in our practice. So now what? One caregiver wants to be added as a guardian, understands they're giving up caregiver payments, or maybe they're not even living in the same household anymore, so they can't continue being a caregiver. Paid caregiver, not caregiver, paid caregiver. Let me be clear about that. But they want now to be co and making legal decisions in a joint fashion. Well, the person who's been the legal guardian sees no reason to change that and doesn't want to add the person. In court, it's a hurdle to get over to get added as a guardian when there's been no need for that and the other person objects. Why would the other person object? Because the communication has broken down and they envision, probably rightfully so, that it will be difficult to make decisions together. That is not every family, but that is some families. Sometimes we have new partners in the mix who are ratcheting up the conflict, not on purpose, perhaps, but it just happens. You know, you don't want that person asserting themselves with any decision-making authority that the ex might have. And a lot of things can happen at that point. Let's say that you are co-guardians and you get a divorce, or you're getting a divorce, and there's a breakdown in communication, and now everything is a fight. You can't agree on a program. You can't agree on transportation. You can't agree on a visit schedule. Oh, I have to stop and talk about the visit schedule. When your person is an adult, there is no more custody after age 18. There's not. It's not a concept. They are an adult. Even if they are under guardianship, there is no schedule of visitation and who gets to see who when. It's up to the legal guardians to decide, depending on the decree. There might be limitations in the decree that are carved out that take that out of the guardian's hands. But most guardianships are going to have full say over who gets to visit, when, where the person goes for visits, and how long and how often. I will often have divorce attorneys come into the mix and say, this is custodial interference. There's no such thing after age 18. It doesn't exist as a concept. You really have to take that parent hat off and put the supporter hat on, because you're in a whole different world now. Let's talk for a minute about what to do if the communication breaks down and you are co-guardians. Like, what happens next? Do you have to go to court to have one person basically removed as guardian? Yeah, that's what you have to do. The standard, though, for removal has to be that the person hasn't performed their job as guardian, or they can't perform their job as guardian because of the communication breakdown. These are tough cases to win. The judges hate them, and you run the risk of the worst thing in the world happening, which is that both of you get removed and a neutral professional guardian gets appointed who you did not pick. You can also spend a lot of money fighting over this, and it's usually not worth it because the outcome is something that nobody's happy with. If you can resolve these issues and work really hard on keeping communication about your child, your adult child, separate from communication about all the other things like, oh, you didn't pay your support this month, or, I'm going in for some kind of a modification, or I don't like your partner. All of those things need to be separated, and you need to have healthy boundaries. There are a lot of ways to get help with the communication process. You can hire a family mediator, not a parenting coordinator. Again, that's back in, minor land, under 18 land. But a true family mediator who can help you communicate with each other. I guarantee you will spend a lot less money on that than you will fighting each other in court and paying the lawyers. The lawyers are the only ones who make out in the deal. And it keeps the communication flowing. You can use an advocate, or what I really like to add to the team is a care manager. a good care manager can do a lot of the legwork and can be the go-between and communicator for the two of you. Again, a lot less expensive than hiring a divorce attorney to come in and fight this out with the unlikely outcome that you get what you're looking for, which is sole guardianship. So I suggest that you think a lot about the communication piece and how you're going to handle this. Even people who come to me and say, oh, we're just fine with the, working out what we need to for Bobby, Sammy, Julie, whoever your kid is. There inevitably comes the breakdown because you are people who may still care about each other, but you're divorced for a reason. One more thing about this. A lot of times people decide that they're going to bring another adult child into the mix at this point and have them be co-guardian or maybe even sole guardian, but in name only, as a placeholder. And so I beg of you, please don't do that. Don't add your adult child into the mix. It's really painful for them to be involved and to have to go between their parents. It's not a role that anyone wants to play at all. So that's a consideration that, I would like you to just think carefully about before bringing that other adult child into what could be a messy situation, messy communication. All right, the second sort of topic to think about with divorce or divorcing parents or even divorcing spouses is estate planning. This is a huge one. So people will come to me and they'll ask me about, how do I set up my separation of assets when I have a special needs kiddo involved? Small children, adult children, whatever the mix may be. And even if we're talking about spouses who are divorcing and one spouse is disabled, should we fund a trust during the divorce? Sometimes that's a good way to go. People will think about this in lieu of a property settlement to each other or as a part of a property settlement to each other. It's an interesting concept. It works in some cases, not many, because a special needs trust can only be used for the special needs beneficiary and not for other members of the family. So it really depends on what your asset situation looks like. I see this more with more established families, people who are on the older side, who, there's enough assets to go around. God bless them. That's not everybody, but in some cases that works. One of the key issues that comes up with any kind of trust planning, how are we going to select the trustees? I don't recommend that exes who are, having difficulty with communication, this is going to be a theme through our entire talk today, communication. I don't recommend that they be co-trustees. It's just not a good idea. I think you need to resolve that one person is going to be the trustee or that it goes to professional trustees. A neutral third party is very often the way to go. As I mentioned in the earlier segment, don't put this burden on your other children. This is probably not a good spot for them to be in. If you are funding a special needs trust for a child, even if it's an adult child, it's a third party trust because they're not entitled to your money. They don't have a claim to it. And if you fund it, it's just like a completed gift into the trust. If you are funding a special needs trust for a spouse, this would be a self-settled trust. It's a completely different planning tool. And We call them D4A trusts. They are self-settled special needs trusts, and it's quite possible to do a trust deposit in lieu of alimony. There's a lot of tax considerations when it comes to funding a trust for a partner, and you want to think carefully and sit down with your planner, make sure they have tax expertise, and even, see your accountant about the ramifications of alimony, payment stream versus a one-time fund into a trust. And then again, you're going to have that who will the trustee be question. Don't pick one of your adult children and put them in charge of their parents' money. It's just a disaster waiting to happen. It might work in a few family situations, but for most people, you're going to be looking for a neutral third party, not even another relative. You don't want information flowing back to the ex about how the money's being spent and all of that kind of stuff. It just should be very professional and very neutral. Let's talk about life insurance. Very often in a settlement agreement, you will have a requirement to carry life insurance to a certain point. That life insurance usually ends when all the kids are, quote, emancipated. That's tricky, very tricky, because emancipation under the law is going to depend on what your state statute says around divorce. And emancipation for real is, a different story, because you may have a child that will be dependent in many ways, and especially financially dependent on your support, even if not legally dependent on your support. So life insurance is a category that you absolutely should get written into your separation agreement, and talk about how long are we going to carry that life insurance, and where is that life insurance going to pay? This might be an opportunity to have a life insurance policy just for the disabled child that goes on past the age of legal emancipation and funds not the other parent, but the special needs trust. Originally, life insurance was meant in a settlement agreement, in a divorce agreement, to replace child support and alimony if the divorcing spouse or the payor spouse predeceases the, expected payment stream. So the life insurance is there to make sure that if we don't have that person working and paying support dollars, we can survive as a family. So think about the life insurance carefully, review this with your divorce attorney, but also talk to a planner at that time about options and what you can do with life insurance planning. Often less expensive to carry a term policy for 10 or 20 or 30 years that will fund during the most expensive time of people's lives. Another question that comes up very often is, well, I've already done my planning. We have one special needs trust. I'd really like to continue just using that trust. This can be very problematic because you selected that trustee list together. You weren't thinking about, were you going to be divorced at the time? And the remainder beneficiaries are important as well, because there is no guarantee that each partner, each divorcing spouse, there's no obligation for them to fund this trust. If you get it written into the divorce agreement, that's one thing, but one parent may continue to funnel their entire estate. Another parent may start a new family and a new life and not have as much for the disabled child, and maybe decide that they don't even need to fund it at all. So it's important to think about realistically, is one joint trust that you both fund going to be the answer? Can you agree on the remainder beneficiaries? Meaning it goes to your other kids and then it goes down your bloodline. But at the end, the ultimate beneficiaries are, if our entire bloodline is wiped out, the money usually in a family situation will get split 50-50 between heirs of father and heirs of mother. Well, if one person is really primarily funding this trust and the other person doesn't put much in it, do you really want those assets, the remainder assets, to go to your divorced spouse's family? Brothers and sisters, nieces and nephews? Maybe you do. Maybe you're very close, you still love each other's families, and this works for you. Maybe you are great at being able to be co-trustees and make decisions together. That's mostly not what I see, but it happens from time to time. This situation, just like the previous situation, just don't put your adult kids, your other adult kids, non-disabled kids in charge. If there's going to be conflict, they don't need to be in the middle of your continuing divorce fight. The better approach is that you each do your planning again. You have to do it anyway because you're taking your spouse off your power of attorney, you're taking your spouse off your will, you're taking your spouse off your revocable living trust, and you're taking your spouse, your divorcing spouse, off of your healthcare proxy. You don't want them making decisions for you, almost for sure. Given that, it makes sense to do a new estate plan and to create your own special needs trust that you're funding. And you're deciding who the trustees will be and who the remainder beneficiaries will be. And it's great if you have a clause in there that allows the merger of trusts. So if two special needs trusts end up being relatively small, the trustee list is pretty much the same, you can merge those two trusts later if there's not implications there. So depending on what the trust clauses say, it's possible that you can merge them so that there's only one trust being run and managed at the end of the day. But most people are going to run two trusts, and that just makes the most sense. Okay, third topic, and that is child support and alimony. And this is a real tricky one. Social Security Administration treats support money as the child turns 18, 100% allocable to the child, regardless of who the payee is. So what does that look like? Let's say, and this is a traditional scenario, but it's not everybody's scenario. Dad's paying mom $1,000 a month of child support. There's two kids, and then they both are nearing the emancipation age. In Massachusetts, that's 21. Most kids are going to stay on and not be emancipated until 21. And if they're still in a college program, it can continue on to age 23. So most states are going to have similar type of emancipation rules, and you need to know what your state looks like for that, or consult your divorce attorney and find out for sure. But Social Security doesn't care about divorce law. They have their own rules. They consider the child support 100% allocable to the child, even if mom's receiving the $1,000. And also, another thing to consider, do you want the child support to go on past age 21 or 23? You can certainly write that into your divorce agreement. It's rare that a state will have an actual law that thinks about or contemplates a disabled adult child. Most don't even deal with it. There are a few. In Massachusetts, our law does not contemplate disabled children who will remain dependent financially past age 21 or 22 or 23. So you can agree together that that one person is going to provide support to another person, to the other parent, especially in this age where adult children are not going out to housing situations and they're at home for decades sometimes. So you can choose to have this written in as a support payment that goes on in consideration of X person's, disability and care needs. Of course, you both have to agree to that. And generally speaking, most people don't, or they don't think about it at all. But Social Security is going to calculate that payment as 100% income to the child, to the adult child. So there's a number of things that you need to think about. How long is that payment going to go on for? Is it 21, 23, or is it some later date? How large is that payment? Are we changing that $1,000 payment to $500 because one child has emancipated and the other really technically hasn't? $500 a month is probably not worth the planning technique that I'm about to tell you. If you have some means and you have parents who are willing to financially support, and bravo for you if you really are considering doing that. In some cases, we will take up a little bit of a complicated fix, which is Social Security allows us to take that income and allocate it to a special needs trust, a self-settled D4A trust. Cannot use the third-party S&T for this. The allocation has to be done by an irrevocable assignment in court by court order. And there's specific language in the Social Security POMS, that's the Program Operations Manual system, that explains how you need to do it. It requires a trip into court, or many states, like our state in Massachusetts, allows a modification of your child support order by joint agreement, meaning if the two of you agree, then you can file the paperwork and you can get your irrevocable assignment without ever having to be heard in court. And there are other states besides Massachusetts that do this. It really streamlines things when people can agree. So let's say that you agree and you file the paperwork in court, takes a month or 2 or 3, whatever the backlog is, and you get your order from the judge that says irrevocably assign this payment of X dollars, $500, say, into this D4A trust. All other details of the separation agreement stay in full force and effect. As long as you don't have the Division of Child Support Enforcement in your state involved, you can do this. If you have a case open with them, you'll have to close it, and then you can do this. Once this is irrevocably assigned, it won't count as income against the child, and then it won't impact an SSI payment or any other public benefits. For example, if you have a Medicaid program, that's a waiver program that has an income limit, it won't impact that as well. So the next step is to file all this paperwork with Social Security, almost certainly having to explain more than once their own rules to them. it really helps in this case to have an attorney who knows what they're doing write a cover letter explaining everything and outlining the POMs and making sure that this gets done right and accepted the first time around. Social Security, believe it or not, they don't see trusts very often, and they don't really understand their trust rules, even though there are like hundreds and hundreds of pages of rules about trusts. But because they don't see them that often, most of the frontline people don't know much about it. But if you can point them exactly where they need to look and they can follow along the checklist that they're supposed to, you can go a long way towards getting this accepted without having to go into an appeal or an informal conference or anything like that. So that's the fix. But there's some things to consider with that because, and this is true of alimony as well. You can have an irrevocable assignment for alimony as well. It's just another support payment. But many payees, AKA a mom, perhaps, are used to having that $500 or that $1,000 just, a check to them, money to them, and they get to spend it however they want or need to. There's no questioning in the court what they spent the money on. Your ex doesn't get to ask about that. But it's very different when the money goes into a trust for a beneficiary. This cannot be used for general household money. It can only be used for the child, the beneficiary child, adult child as it may be. And that means that, you're now opening a trust bank account and you're running a trust maybe sooner than you expected. And this is why I say carefully consider whether that child support payment is large enough or meaningful enough to you to go through this court process and then to do a little bit of, over the fence, and through the hills and dales with Social Security. But once you get it all set up, you can have your cake and eat it too. The Social Security payment can be used to pay room and board to the family member that they are living with. That will replace the money that you were getting for support dollars. So room and board payment to the, live-in caregiver, mom, AKA, most of the time, not always. And you use that money however you see fit. It's not a taxable event to have someone in your family chip in for expenses in your household. And then you can use it to pay mortgage, taxes, rent on an apartment, insurance, food, whatever you need. It's certainly not going to be enough, but the money that is sitting in now the D4A trust that comes in every month from the support payment, and it must be paid directly to the trust, you can use for other things, medical copays, equipment, an iPad for Junior, trips, anything directly related to that person. And a D4A trust can pay for pretty much anything. This is not a primer on trust, but I do want to just mention that, it's about 50-50 with the families that I see, whether it's worth it for them to do this, hopping through court, hopping through Social Security. Sometimes they just agree to close out the child support. And again, thinking about, the issue number 2 in the planning, does it make sense to, take a lump sum and fund an SNT third-party trust instead of doing the monthly support payments through the child support? It's a good way to go if you can afford to parse off part of the money. Sometimes you're selling a family home, and before you make the split between parents, maybe, take X amount of dollars for a few years of support payments that would have been paid and pop it into the trust. And then work through those issues of who will be the trustee, et cetera, et cetera. So that's pretty much it on the 3 issues that are kind of front and center for divorcing parents or divorcing spouses. I hope this has been helpful to you, and I hope that you dig in a little further with your circle of care team members, whether it's your attorney, your tax advisor, your CPA, your financial advisor, and just kind of talk through, and hopefully with your ex-spouse, hopefully you have that level of communication where you can make some good decisions for your loved one or for yourself. Thank you. And this will end the recording now. Love to see your comments in the circle. If you have anything that you want to ask or say, please go ahead and let me know. This will be posted soon.